Fairness. Fairness is essential to justice in the court. And we are going to talk about fairness and the standard the judge must look to when reviewing a citizen's complaint against a federal circuit court judge. So let's get started. Yes, in evaluating the case, the judge has a standard, and there are two areas of evaluation by the judge that you need to be aware of. For those of you who may not know the statutes, I want to introduce two. 28 USC 351A states the following: any person alleging that a judge has engaged in conduct prejudicial to the effective and expeditious administration of the business of the courts, or alleging that such judge is unable to discharge all the duties of office by reason of mental or physical disability, may file with the clerk of the Court of Appeals for the circuit a written complaint containing a brief statement of the facts constituting such conduct. 28 USC 352A states, the chief judge shall expeditiously review any complaint received under Section 351A or identified under Section 351B. In determining what action to take, the chief judge may conduct a limited inquiry for the purposes of determining. And I'm going to allow you to complete that by reading the statute. But for the purposes of this video, I want to hone in on the chief judge's obligation to make an expeditious review of the complaint. So let's look at two standards. To help me illustrate the first standard, I want to look at two cases here, and then we'll get into the specifics about that standard. Barnes versus Winchell. There was an unsettled factual question on whether the judge used his judicial office to vindicate a personal vendetta against the plaintiff. The court concluded because there were unsettled factual questions, it was necessary for the parties to conduct discovery. And in the matter of Henry DeLorean Motor Company, the court was clear that the law is settled. The court said there cannot be any disputed questions of facts at this stage. The court must accept plaintiff's factual allegations as true and determine whether the plaintiff undoubtedly can prove no set of facts in support of his claims that would entitle him to relief. In other words, when the chief judge is reviewing the complainant's complaint, the chief judge shall not undertake to make findings of fact about any matter that is reasonably in dispute. In conducting a limited inquiry under subsection B of 352, the chief judge must avoid determinations of reasonably disputed issues, including reasonably disputed issues as to whether the facts alleged constitute misconduct or disability, which are ordinarily left to the Judicial Council and its special committee. Let's look at the second standard, the motion for summary judgment. When a chief judge reviews the complainant's complaint, the judge uses the same standard used to decide in a motion for summary judgment. Now, you would find this discussion in the commentary in the Rules for Judicial Conduct and Judicial Disability Proceedings, Chapter 3, page 20. You've got to get familiar with these rules. And I will leave you a link in the description page of the video. Now, let me digress a little bit here. What I learned recently is that sometimes YouTube would take down certain links. They have their reasons for it. My point here is you need to download the link immediately in the event YouTube takes it down, okay? So, of course, Federal Rules of Civil Procedure governs summary judgment motions. Under Rule 56, in order to succeed in a motion for summary judgment, a movement must show one, that there is no genuine dispute. There we go again, genuine dispute as to any material fact, and two, that the movement is entitled to judgment as a matter of law. This is a standard that the chief judge must look to. And you can read Anderson versus Liberty Lobby, a U.S. case 1986. And the case will give you even a clearer understanding on the matter in dispute. Okay? The next thing I want to talk about is what is deemed to be cognizable misconduct. And you can find this information at Rule 3H1, A through I of the Rules for Judicial Conduct and Judicial Disability Proceedings. At page 7, there is a commentary discussion that is very interesting. And again, I will leave that link in the description page of the video. 1. The judge using his or her office to obtain special treatment for friends or relatives. 2. Accepting bribes, gifts, or other personal favors related to the judicial office. 3. Having improper discussions with parties or counsel for one side in a case. We call that ex parte communication. 4. Treating litigants, attorneys, or others in a demonstrably egregious and hostile manner. 5. Engaging in partisan political activity or making inappropriately partisan statements. 6. Soliciting funds for organizations. 7. Retaliating against complainants, witnesses, or others for their participation in this complaint process. 8. Refusing without good cause shown to cooperate in the investigation of a complaint under these rules. 9. Delaying a particular decision or habitually delaying a significant number of unrelated cases. Now, this list is not exhaustive. I encourage you to read the rules because it will help you to understand what is cognizable misconduct. Regarding a judge's review of an order, a complainant or judge agreed by a final order of the chief judge under this section, that's section 28 USC 352C, may petition Judicial Council of the Circuit for review. The denial of a petition for review of the Chief Judge's order shall be final and conclusive and shall not be judicially reviewable on appeal or otherwise. Again, to obtain a complaint form to file a judicial misconduct complaint against a federal circuit court judge, contact the judicial council in the circuit the lawsuit is filed. Better yet, you can even go to the court website and download the complaint form. Now, make sure that the information that you're going to rely on to make your complaint is well founded and well documented. The judge may call it frivolous. And remember, though, the complainant can file a petition for review pursuant to 28 U.S.C. 352C. I am always happy to come to you with information that can help you get justice in your lawsuit. And as always, I look forward to coming to you. I am Advocate Lucinda, your empowerment lawyer. See you next time.